Well, hello, everybody. That was an adventure. I hope that people are out there. It's been trying to find the right room was certainly fun, but here we are. We've got a couple of really great papers for everyone to react to. And these papers are the result of a call for papers that was sent out by the AALS section on sexual orientation, gender identity issues. I'm Jack Harrison, the outgoing chair of the section, so I welcome on behalf of the section. Since we're starting late, I'm going to go ahead and do the introductions, and then we'll move right into presentations. Presenting first will be Marie Amelie George. Professor George is at Wake Forest University School of Law. She specializes in LGBTQ rights and teaches courses on civil procedure, family law, and public interest advocacy. Her work has been published or is forthcoming in the Northwestern Law Review, Florida Law Review, Wisconsin Law Review, Alabama Law Review, Harvard Civil Rights, Civil Liberties Law Review, and Law and History Review. In 2018 and 2019, she received Duke Minier Awards recognizing her scholarship on sexual orientation and gender identity. Commenting upon Professor George's paper, and her paper is Expanding LGBT. And commenting upon the paper will be David Cruz from the University of Southern California Gould School of Law. Professor Cruz writes about and teaches a variety of classes on constitutional law, LGBT law, past chair of the AALS section on sexual orientation and gender identity issues. Professor Cruz has, since 2010, been teaching a specific transgender law course that includes intersex and non-binary issues, and most recently co-authored with Jillian Weiss of Gender Identity and the Law, the first legal text of its kind, which has just been published by Carolina Academic Press. So congratulations, David. And then presenting his paper, Anibal Rosario Lebron. His paper is Weaponizing Personal Freedoms, a Crisis Lens Analysis to Sex, Gender, and Sexual Equality. Professor Rosario Lebron is a Puerto Rican professor, attorney, linguist, and photographer. He holds an LLM in legal theory from New York University, a JD postgraduate certificate in linguistics, and a BS from the University of Puerto Rico. He is taught at Universidad de Puerto Rico, Hofstra University, University of Louisville, and Universidad Interamericana. Currently, he is at Howard University School of Law. He's a member of the board of directors of LATCRIT. His research examines the interconnection between evidence, family, criminal, and constitutional law from a cross-disciplinary lens. Specifically, he studies how to reform the law to empower groups such as women, LGBTQ plus people, and minors in their pursuit of equality. Commenting upon Professor Rosario Lebron's paper will be Kyle Velty. Professor Velty is from the University of Kansas School of Law, where she teaches evidence, torts, employment discrimination, and sexual orientation in the law. Her scholarship, which examines the intersection of sexuality, gender in the law, has appeared in law journals including the Yale Law and Policy Review, Brooklyn Law Review, and Connecticut Law Review. Her recent scholarship focuses on the perceived tensions between religious liberty and LGBT civil rights. She filed amicus briefs in the United States Supreme Court cases of U.S. v. Windsor, Obergefell v. Hodges, Masterpiece Cake Shop v. Colorado Civil Rights Commission, Harris Funeral Home versus the EEOC, and Fulton versus the City of Philadelphia, and has appeared in the media discussing issues of religious liberty and its connection to anti-discrimination law, Title IX, and marriage equality. So with those introductions, we will turn it over to Professor George and look forward to hearing your paper.
Hi, everybody. It looks like I'm muted on there. Can you hear me? Great. This is weird. I'm used to Zoom. This is a different Zoom. And so I can't see who's there, but in the earlier version, there were some familiar names. I'm excited to not see you, but know that you're there, and hope I will get to meet the rest of you at some point. I'm also really curious as to how people start their classes by having people put things in the chat, and I would love to hear that in the Q&A. All right, so with all that aside, thank you for being here. I know that between Georgia elections and the shenanigans at the Capitol, and by shenanigans I mean treason, and the ongoing pandemic and the upcoming virtual semesters, all of you have too much to do. So I really appreciate you coming and attending this session, and hopefully we'll have a great discussion from it. So this piece is the third in a series that I've written on the LGBT movement. The first one, which I published in 2018, looked at how the LGBT movement formed. How was it that gay and lesbian rights organizations became LGBT rights organizations? The second, which came out in, I think, 2019, was on the relationship between transgender and non-binary rights. So the first one looked at the past, the second was on the present, and in this one, I'm looking towards the future. Specifically, I'm asking, what would it mean for LGBT rights groups to become LGBTQIA rights groups? Before I get into the paper, I'm going to take a moment to just give some quick definitions so we're all on the same page. I imagine most of you are familiar with all these terms, but just in case. Q stands for queer, which is a broad term that encompasses anyone who is not heterosexual or gender conforming. So gay men, lesbian women, transgender individuals may all identify as queer. That said, in this paper, I limit my discussion of queer to non-binary because that is where the interests are different. So although I'm talking about queer, for purposes of this paper, I'm limiting it pretty substantially. I stands for intersex, who are individuals born with variations in sex characteristics, meaning their chromosomes, genitals, or secondary sex characteristics are not clearly male or female or have elements of both. A signifies asexual, who are individuals who are generally not sexually attracted to others, and they don't desire to engage in sexual intimacy, or sexual activities, not intimacy, sorry. Asexuality is a sexual orientation, which distinguishes it from celibacy, which is the decision to not engage in sexual activities despite desire. What got me thinking about this topic was actually teaching a clinic on sexuality and gender law. One of the projects that students were working on was doing research on LGBT rights for an outside organization, and the organization had said LGBT rights. And my students kept using the acronym LGBTQIA. So when they added QIA to LGBT, they changed the scope of their project significantly. And the reason they did that is they saw LGBT and LGBTQIA as being one and the same. And really, the acronym LGBTQIA is increasingly pervasive. It might seem to be the default for many of you. But national organizations are really LGBT in their activities. They don't represent the additional identity categories in large part. So that led me to my initial research question, which was, what would it mean for national LGBT rights groups to be national LGBTQIA rights groups? My article starts with background on social movements and social movement expansion, and the literature on that indicates that identity and strategy are really the twin pillars around social movement formation and mobilization. And it's a large part of the paper. That is all I'm going to say about it in the interest of keeping this talk to a reasonable amount of time. But just know that I'm going to organize things around identity and strategy. And so my talk is going to focus on each of non-binary, intersex, and asexual to tease out how it is they're connected to LGBT as a matter of identity and strategy. And then I'll finish with this larger question of what a national LGBTQIA rights agenda would look like. And what I hope that my paper and my talk convince you of is that LGBTQIA would require national organizations not just to add QIA issues to their agenda, but to rethink what LGBT means, what those interests are. National organizations pursue goals that benefit some members more than others. And the expansion would shift their priorities and agendas in ways that affect which people within LGBT the national organizations are representing. And that's because QIA interests overlap most with currently marginalized members of the LGBT community. So that's the overview. That was long, but we'll get into the meat of it. So let's start with non-binary, which I'm using in lieu of queer. So when I say non-binary, I mean individuals who don't identify as either sex, may identify as both sexes, or sometimes identify as one and sometimes another. And non-binary identity can be considered one type of transgender identity. Approximately 0.6% of the US population is transgender. In the most recent US transgender survey, about a third identified as non-binary, which gives us approximately 0.21% of Americans being non-binary. When applied to current population estimates, we're talking about 700,000 people in the US, which is about the size of Washington, DC. So we're talking about a pretty significant population. And national LGBT rights groups are often nominally LGBTQ. The more expansive acronym signifies inclusion, but as a practical matter, they often do not really represent non-binary interests. In terms of this identity strategy dyad that I laid out as the organizing principle, there's a clear identity basis for LGBT expansion insofar as non-binary individuals violate gender stereotypes and gender norms. And that's what got us the LGBT movement in the first place. Gay and lesbian rights advocates and trans advocates recognized that all of the groups were discriminated against when they failed to conform to gender stereotypes. And that's what led to the formation of the LGBT movement. But that same identity basis that would make non-binary a shoo-in there's an identity sort of basis for the coming together, but strategy really and strategic considerations impede the movement's expansion to include non-binary. And that has to do in large part with opposition arguments. One of the main arguments that transgender rights opponents make is that gender identity protections and anti-discrimination laws will grant men access to women's facilities. That was the main argument that opponents of LGBT rights made in 2018 when they initiated several ballot measures to repeal state and local gender identity anti-discrimination protections. To counter those opposition arguments, LGBT rights groups have tended to feature very gender-conforming trans individuals in stereotypical settings. So some examples from the ballot measures. One ad featured a bearded man in a suit and tie at work. Another showed a trans woman in a sparkly dress and high heels on a catwalk. In yet another ad, that same woman was in a kitchen pulling cookies out of the oven. So the argument that LGBT rights groups have made for trans rights is that trans men are men and trans women are women. And that is an accurate statement for these trans individuals. But the claim that trans men and women don't undermine traditional gender norms and that trans identity actually promotes the gender binary really excludes non-binary individuals from the conversation. So non-binary individuals don't fit national organizations' approaches because non-binary identity explicitly challenges the gender binary and also challenges the notion that gender is a relevant trait for us to organize ourselves around. So non-binary identity undermines the organization's arguments in these spaces and creates a strategic tension. There are ways around them, but the tension currently exists. So strategic tension, even though non-binary really fits and belongs as a matter of identity. So that's non-binary. Next is intersex. Intersex individuals have discordant sex characteristics. So an intersex individual may have a feminine physiology, but produce increased levels of testosterone. A different type of intersex condition can give rise to enlarged clitoris that looks like a penis. And studies indicate that up to 1.7% of the population is intersex, but intersex is an umbrella term for a variety of characteristics, so most of these intersex conditions are invisible. The way intersexuality relates to LGBT is that it really embodies a physical challenge to the gender binary or the sexual binary. It's a biological challenge rather than the gender identity challenge that non-binary identity poses. But because of that, there is an identity-based link between LGBT, non-binary, and intersex. But there are tensions on both the identity and strategy elements. So the main focus of intersex rights advocates has been to end gender normalizing surgery on infants. Since the 1950s, doctors have been operating on children with ambiguous genitalia to make them appear as one sex or another. As a result of those operations, intersex individuals may have heavy scarring, be rendered infertile, or suffer from a loss of sexual sensation. And intersex advocates argue that children should be raised as male or female, but that irreversible medical conditions should wait until the children are old enough to consent. And the space of medical regulations and access to care is one of the sources of conflict between intersex and trans rights advocacy. Intersex advocates want to stop surgeries, while trans rights advocates want to expand access to medical treatments. Although their goals lead in opposite directions, that's not the strategic issue. What's important about it is what it tells us about how they understand gender identity. For intersex advocates, gender identity exists irrespective of physicality. And for that reason, doctors do not need to make intersex bodies align with their gender identity. Gender identity will form regardless of what the individual's body will look like. For trans rights advocates, the physical body is really important to gender identity development. And so what matters less is about the fact these goals lead in opposite directions is that they reflect a fundamental identity-based difference on how the groups conceive of gender identity. So although there's that difference, intersex, transgender, and non-binary rights advocacy can really support one another. States and cities have been increasingly offering non-binary gender designations on identity documents. When they do that, one of the main objections they get from the public is that sex is a physical fact that is separate from gender identity and that there are only two sexes. But intersexuality has really undermined that premise by providing a biological underpinning for non-binary arguments, and it's proved quite convincing to lawmakers. So just like there are points of tension and convergence between LGBT and non-binary, same is true for intersex and LGBT and Q rights. So that's intersex. I'm going to turn to the third group, asexuality. Asexuality is a sexual orientation marked by a lack of sexual desire, but aces may be romantically interested in others, meaning they want to engage in physical activity like kissing. That desire tends to be directed at a particular gender, so aces may be heteroromantic, homoromantic, or biromantic. Aces may also identify as transgender or non-binary. Studies have estimated that aces are 1% of the population, but that figure is probably under-inclusive. Asexuality is related to LGBT pretty definitionally, since asexuality is a sexual orientation. And so asexuality really expands how it is that we understand what sexual orientation is. Instead of the Kinsey scale with homosexuality on one end and heterosexuality on the other and bisexuality in the middle, we have a spectrum with homosexuality, bisexuality, heterosexuality, and asexuality. So asexuality really helps highlight that sexual orientation is more than homosexuality and heterosexuality. That said, it's a sexual orientation based on the absence of sexual activities, which is a little bit at odds with the early gay and lesbian rights movement, which focused on people's right to engage in sexual activity. And one of the main impediments to national organizations representing ACEs is that discrimination against ACEs isn't all that intuitive. I think people ask, how is it that people can be discriminated against for not doing something? But studies have shown that people have more bias against ACEs than any of LGB or T. And in law, that discrimination comes in the form of the veneration of the marital couple. Now, discrimination against singles isn't an asexual specific issue, but it affects ACEs disproportionately. And given that the LGBT movement spent 2.5 decades fighting for marriage equality, I think it's safe to say that it's more invested in maintaining marriage rights than in seeking alternatives to marriage. On the other hand, many individuals within the LGBT movement want recognition of their non-marital relationships. And that means that ACE inclusion might inure to their benefit by promoting changes in family law. So just like the other categories, asexuality both pushes the boundaries of LGBT and brings it closer together. So those are all of the identity categories I go through in the paper: strategy and identity-based connections and dissonances. I'm briefly going to talk about how these connections apply to the national LGBT movement and its possible expansion to any combination of LGBTQIA. So some of the interests of non-binary, intersex, and asexual individuals are aligned with current national LGBT organizations' priorities, but many are not. And that means expanding from LGBT to LGBTQIA wouldn't necessarily shift what is on the group's agenda. And that change is relevant not just to non-binary, intersex, or asexual individuals, but also members of the LGBT community who aren't currently represented by national rights groups. At the beginning of this talk, I said that LGBT rights groups succeeded through assimilationist arguments. And there's an array of scholarship that shows that these arguments have primarily benefited the white, wealthier, and gender-conforming gays and lesbians within the movement, while marginalizing other community members. Because of the organization's priorities and arguments, many LGBT individuals who are lower income or racial minorities tend to say that the groups don't represent their interests. And that could change with an expansion to LGBTQIA. Doesn't mean that expansion is the only way, it's just a possibility of a reconceptualization. Non-binary rights promote the interests of non-conforming gays and lesbians. Intersex advocacy does too, since it challenges the claimed naturalness of the gender binary. Asexuality also provides a different conception of relationships and families that is important to many LGBT individuals. And so the result is that expanding to LGBTQIA may change which parts of LGBT get priority, prioritizing the gender non-conforming members of the LGBT community. So those who have been marginalized may find their interests better represented. The additional categories would also bring in people who are theoretically part of the movement, but haven't seen their interests prioritized. Now, the flip side of that, of course, is that moving to LGBTQIA in changing the contours of the movement means that organizations may simply balk at expansion. So an LGBTQIA movement is certainly possible, but it's not inevitable. And bound up in this question of what a LGBTQIA movement would look like, the question I started with, is another, I think, more fundamental question of what the LGBT movement is, as well as what it should be. So I'm going to leave it there. Again, thank you so much for coming, and I'm looking forward to hearing your thoughts and getting your questions.
You're on mute, Jack.
Sorry, I was muted. Thanks so much for the presentation, Mariamali. David, I know you have some thoughts to share, so turn it over to you then.
Great. Thank you very much, Jack. In the interest of time, given our start, I'll skip over my praise for legal historian and social movement scholar Mariamali George's already impressive body of work and turn to her article, Expanding LGBT. In treating non-binary gender and asexuality in particular, the article builds in areas that have some significant legal scholarship, but not much. As with Professor George's previous work, this article displays admirable care in the articulation of its many claims. It often concludes, for example, that particular factors may or might have or have had certain effects or possibilities, and I applaud this scholarly attribute. I myself am neither a legal historian nor a sociologist, though I count both among my friends and colleagues, even just at USC Law. But I do have a methodological question about what should count as evidence and proof in this article's context. Expanding states, quote, the strategic gap between LGBT and non-binary explains why there are currently national LGBT rights organizations rather than LGBTQ ones. Without more, the strategic gap may be consistent with that observation about national organizations, but doesn't seem to me to explain it. One might well think that state or local organizations would face very similar strategic gaps, as well as the, quote, trade-off between a campaign that educates individuals on the spectrum of trans identity identity and one that secures immediate legal gains. So it's difficult for me to think that the strategic gap by itself explains why there are not national such organizations when there are state/local such organizations, as the article notes. Now, regarding non-binary gender and people and rights, I have little to quibble with in the article. I'm a law professor, so when I say little, I don't mean nothing. In particular, I'd like to ask about the following possibly just implicitly phrased passage, part of which Professor George quoted in her presentation. The article states, LGBT rights groups ultimately settled on the argument that transgender men are men and transgender women are women, a statement that is true for many transgender individuals, but not all. I'm unsure about the last three words. What would be an example of a transgender man who is not a man? Also, perhaps a quibble, because it doesn't go to anything central to Professor George's analysis of national LGBT organizations' rhetoric in resisting efforts to repeal protections against gender identity discrimination, but to a different argument she addresses in a footnote. Following Professor Naomi Schoenbaum and other uncited folks as well, the article criticizes attorneys for trans plaintiffs in Title VII cases who have, quote, argued that transgender individuals were discriminated against as a result of stereotypes concerning how men and women should act. George says this, quote, reifies a person's sex assigned at birth, close quote, because the argument espouses that, here quoting Professor Schoenbaum, quote, a transgender person designated male at birth is an effeminate man, not a woman, end quote, for example, whereas, quote, this view of the sex of transgender persons is contrary to transgender persons' own identity. I address such contentions in Acknowledging the Gender and Anti-Transgender Discrimination, a 2014 article that neither George nor Schoenbaum even cites. Title VII doctrine does not require a transgender woman plaintiff to plead that she is a man perceived as unmanly, nor does it require a court or a judge or a legal doctrine to maintain that she is a man. It is enough to plead or for the courts to conclude that the employer so regarded her. And that, I would submit, does not have nearly the reifying effects that the former positions might be thought to cause. While Schoenbaum recognizes this eminently defensible view of the requirements of Title VII doctrine, she relies on the contingent fact that most courts have not so applied it for transgender plaintiffs. However, it doesn't appear that Schoenbaum notes in some of these cases plaintiffs' counsel made the objectionable characterizations of their trans client's sex. Schoenbaum also doesn't grapple with the judicial reasoning of transgender woman Diane Schroer's important victory against the Library of Congress. Turning to intersexuality, I have a little more to say about expanding LGBT. In the category of causal questions that I have, the article appears to attribute a mid-2000s flourishing of legal scholarship on intersex issues solely to, quote, advocates lobbying for a moratorium on infant genital normalizing surgery. But to me, this overlooks the transformative impact of Julie Greenberg's landmark 1999 article, Defining Male and Female, Intersexuality and the Collision Between Law and Biology, and Greenberg's subsequent scholarship. Expanding LGBT only cites one later article by Greenberg. And since I'm on the topic of giving credit, I was surprised to see no mention of Suzanne Kessler's important sociological work on intersexuality, whether alone or with Wendy McKenna. My next question for Professor George is whether the following is a substantive or a wording issue. The article states, intersexuality differs from LGBT in that the category centers on physicality, and yet the non-normative nature of intersex bodies creates a kinship between the identity groups. This makes me nervous, for unless the article only means to be positing kinship between intersex people and trans people, not LGBT people generally, it sounds like it suggests that the very bodies of lesbian gay people are different from those of heterosexually identified people, which recalls the various places in which heterocentric medicine had tried to locate a physical manifestation of homosexuality or bisexuality, as I long ago noted in Controlling Desires, Sexual Orientation, Conversion, and the Limits of Knowledge and Law. It's also not clear to me that, to quote the article, intersex overlaps with non-binary because the categories insist that dimorphic gender is unnecessary. Setting aside the anthropomorphizing of these categories or identity traits as insisting, significant numbers of intersex people do self-identify as having a gender from those of the conventional binary. It's sex that their bodies more easily show might not be dimorphic. I'm also not sure I agree that, quote, for intersex advocacy, surgery merely addresses appearance and the body irrelevant to sex. Rather, for some intersex advocates, anatomy can be relevant to sex/gender, but as Professor George said in her comments, should not be surgically altered without a person's own consent, unless necessary, for example, to save an infant's life. I'll only raise one main question about the article's treatment of and arguments about asexuality. In addressing connections between lesbian, gay, and trans people, enlarging LGBT states, the identity-based connection, which ultimately united the groups, stemmed from the fact that they all violated gender norms, and this was the reason for most of the discrimination they endured. But is this really true of asexual persons? The injunction to be sexual, whether heterosexual, lesbian, gay, bisexual, or pansexual, does not instantly appear to be a gender norm. It does not obviously command one thing for some people and another for people of a different sex gender. This complicates the article's later simple claim that there's a connection between lesbian gay people and asexual people because both are defined by a sexual orientation or perhaps a sexual orientation that's stigmatized. If Professor George is committed to these notions of sexual orientations and of their uniting force, would she extend this to pedophiles? People opposed to lesbian gay rights sometimes say pedophilia is a sexual orientation, so why don't bans on sexual orientation discrimination protect them? And so let's not enact such bans. But again, pedophilia does not immediately appear to be a sexual orientation defined in terms of sex/gender or violation of gender norms. I'll close these comments with a plaintive question, perhaps informed by my history of involvement with national LGBT and civil rights civil liberties organizations. Although expanding LGBT says it does not prescribe, but merely describes possibilities with costs and benefits for national LGBT organizations, what are organizations to do? Although the article superficially sounds like it makes a descriptive claim that, quote, national organizations have not questioned the appropriateness of restroom sex segregation itself, it's hard not to read that in the context of the article as a criticism of national LGBT organizations. After all, the paper charges them with failing to represent the interests of some members of their ostensible constituencies, which sounds normatively negative to me. The sex-segregated restrooms discussion in the article would be a little easier to embrace as criticism if the article were to explain a little what the legal basis or bases there could be for such challenges, explain some informed estimate of non-trivial chances of success today or on some specified time horizon, or otherwise explain why even futile such efforts could be worth the litigation defeats for some other kind of gains. After all, the paper concedes that sex segregation, quote, is exponentially more challenging to question than definitions of eligibility for such sex-segregated spaces. Similarly, the paper seemingly criticizes national organizations' arguments that binary transgender people are harmed by being relegated to, quote, private or unisex restrooms for, quote, ignoring the existence of non-binary individuals who may well prefer private or unisex restrooms. However, non-binary people with such preferences seem unlikely to object to provision of private/unisex restrooms. So what exactly? The paper could make this clearer. Regardless of any of the foregoing, expanding LGBT is yet one more important article from Professor George, who I have no doubt is well on her way toward a successful tenure decision and a long career as a legal scholar, and I commend the article to you all. Thank you.
Thank you, David. Marie-Amélie, I know that you've probably got some thoughts and responses to that. Given our time at this point, though, I think I want to perhaps you can have that conversation offline, or maybe we'll have some time at the end, but I want to make sure that we give Professor Rosario Lebron adequate time as well. So I'm going to turn it over to you, Anibal. You can take over.
Yes. Thank you. I wish we can see each other, but Happy New Year to everyone that is in the room. I'm going to share a presentation because I'm kind of a very visual person to explain my paper. So, as Professor Harrison mentioned, the title of my paper is Weaponizing Civil Liberties, a Crisis Lens, Analysis to Sex, Gender, and Sexuality. And this work comes from a seminar that I teach on sex, gender, and sexuality, and looking at all the current cases and litigation that is occurring in these topics, right? And from that, I started thinking about what are some of the common threats that keep moving the right to try to put a halt on gender sex equality. And one of the first things that obviously comes to mind is the multiply control over courts, right? To pack the courts with conservatives. That's one of the issues. The other is the amplification, and I'm going to go through all of them in more detail later, but the other one is the amplification of constitutional protection statutorily. For example, DOMA or RFRA. Another is the adoption of minorities litigation strategies, and that has two forms. One is creating entities like Latino Justice or the NAACPA to litigate these cases, and also using some of the arguments that minority groups have used in the past to advance their rights. And there you see the litigants in the Master Cake case. Another one is the depiction of the conservative groups as nascent minorities, and you see their feminists are the majority in that picture. And part of that is also reshaping the narrative of whether their conduct of refusing to serve LGBTQ plus people is bigotry or not. And the last one is a temporary embrace of outcomes in favor of minorities. For example, Bostock. We see some kind of progress there, but that could be halted soon by other decisions that are coming from the Supreme Court. So first, you can see how the courts have been changing through the last administrations, and definitely conservatives have been packing the courts, and this has been studied widely, so I'm not going to go into details of how many judges you can see not only into the Supreme Court, but also into the appellate and into the trial level courts, and the same is happening in some states as well. The other thing that you will see is the creation of RFRA status, right? That amplify the protections of religious liberties. And you can see here, half of the country have some kind of protection on that, or creating RFRA, or requiring the Constitution to have the RFRA-like scrutiny. Let me go to the next one. Did it go? There we go. Oops. And the other one that comes to that is that some states, and this is part of the litigation that is happening, have discrimination laws, and they come into opposition to the RFRA status. And we see the litigation and how the litigation tends to come in favor of the RFRA defense. And I'm going to go about what are the details and what is important. And this is ADF, which is one of the main institutions providing pro bono services to all these litigants and seeking litigants, and shaping the litigation strategies and shaping the discourse. They even create content for the web to promote the cases and to talk about the issues. So that's a very important part of changing the narratives that are happening today. And these are some of the cases, and these are that are related to religious freedom. You can see they're trying to exempt public accommodation laws, right? Not following those, denying protection services based on gender, attempting to circumvent employment protections, like in Bostock, and we'll see what that happened, depriving sex-and families the right to raise children, attempting to continue with conversion therapy, and in the case of New York, that was pretty successful, and curtailing also medical service to women on reproduction. And as well as refusing to the recognitions of trans people. There are, I would say, now 5 cases that goes into professors refusing to use the preferred pronouns of students, and alleging violations of their free exercise and also the free speech. The same happens with the free speech, right? We can see how the free speech is being used to prevent women from accessing accurate family planning information, using to curtail the prohibitions against conversion therapy, trying to exempt public accommodation laws, and again, refusing the recognitions of trans people. And this is something that scholars have been pointing out. It's not something necessarily new that I'm bringing to that. The crisis analysis that I will be talking about is my contribution. You can see Catherine McKinnon talking about how the free speech that was once a defense of the powerless has now become a weapon from the powerful, right? And how it's being weaponized, and like the Lochner era has been weaponized. And it's true. We can see the results in terms of the Supreme Court, how in cases of free speech, the win for conservative speech has risen up, and how the decisions have been changing with the packing of the courts, right? So that first step of putting all of these judges have had a clear impact on the decisions. And even the Supreme Court justices have pointed it out. Here we have Justice Kagan talking in Janus about this and saying how it's alarming that the First Amendment is turning into this sword that can go into every little aspect of our lives, right? And what it was not meant to actually protect, amplifying those protections in that way. This is have an impact in the type of legislative action that states are trying to put forward. So in New York, there was a prohibition against conversion therapy. There were challenges, and the legislature decided to repeal the ban because of fears of what the litigation outcomes of those cases will be. So it having that effect. The conservative strategies are also working in shaping them as a minority and having an impact in the litigation. And we can see the change in the animus doctrine, for example, in the Master Cake case, and how they are changing the protections of the animus doctrine to protect a majority, and also expanding, right, its contours more than it was previously done, protecting LGBT people. And this is the important one in terms of reshaping the narratives. And I'm going to play part of this video so that you can see what I'm referring to. And this is prepared by ADF as part of their litigation media efforts. And let's see if it plays.
As we kind of lived out our lives and time went on, we just found this overarching theme in our lives that we love marriage. And so,
hold on, sorry about that.
We need instruments like telescopes to help us see reality more like it really is. And so the whole purpose of Telescope is to, regardless of what project we're doing, to glorify God and make much of Him in every project that we do. We will hopefully always be able to direct events and do concerts or the work that we're doing right now. But I want to tell stories that are going to matter for eternity. I want to tell marriage stories. I want to tell stories about the glory of God in marriage, because not many people are.
So here's the situation that Carl and Angel face in Minnesota.
Hold on, because I was trying to get to the point where they talk about their family. Here it is. Sorry about that. And how they are inclusive,
actually,
including gay
another
people.
child that we're raising basically as our own. As we kind of lived out our lives and time went on, we just found this overarching theme in our lives that we love marriage. And so we've had people on our couch several times, premarital counseling, talking about how do I do this? How do I love my spouse? Even officiating weddings, because we just really believe in the institution of marriage. We believe having convictions causes us to move towards people that are different from us.
We love having a diverse group of people around our table. I feel like it makes our lives richer. Our table is the central focus of our house. It's 12 feet long, and the first time you come, you get to sign your name underneath it with a Sharpie. It's so fun to be able to lay underneath it and just see all the hundreds and hundreds of names.
There's people around our table regularly who are very, very different from us and who hold different political views, different religious backgrounds, or members of the LGBT community. We love it. We love having people in our home who don't agree with us and getting to know them and do life together.
Right. So you can see they love to have gay people in their houses, but they wouldn't
Knowing
like to
that
have
the state of Minnesota has
them serve them by providing services to them in their weddings and their videos. So looking at this, I started to think, what is happening here? What type of theoretical framework I can come to understand what is happening here in terms of the litigation strategies? And I went back to one of my favorite political philosophers, which is Antonio Gramsci. And Antonio Gramsci was trying to understand the success of fascism in Italy. And he talked about a crisis that was happening. And this is the way that he described the crisis. The crisis consists of precisely in the fact that the old is dying and the new cannot be born. In this interregnum, a great variety of morbid systems appear, right? And that interregnum, it's what I think we're happening here. We see some of the morbid symptoms that we have talked about in this way. One of them is those positive results that we can see in some of the cases as postdoc. We also see some of the morbid results in which is people packing the courts, right? Forcing that physical access that Gramsci talks about, in which they enforce that, retaking or reappropriating narratives that were from minority groups to being used now for their advantage. That's also part of the morbid symptoms. So I intend to use this framework to understand this. And part of that is looking at the crisis that Gramsci talks. And he says a crisis can be latent and explicit, right? Latent crises are things that happen often on everyday life in which we are debating and the hegemony discourses are changing, right? But nothing really big happened. There's no big change. And they're explicit, in which part of the system, it's now being attacked and it's getting broken. And we see an impact. And that is what's happening here. We can see the changes in gender norms, in sex norms, and in sexuality norms that have been happening. And this is what Gramsci also called an organic crisis. An organic crisis is when the leading group is no longer leading, is ruling, right? And part of that is using that physical access, having access to the courts, right? And packing the courts, creating legislation that impacts the way that people are living their lives. And looking at that, he looks at 3 steps, right? The processuality, the organicity, and the morbidity. And the morbidity are all those things that I showed you at the beginning. And what Gramsci says is that this is an inflection point. And in this inflection point, we have to take advantage of it. So if we don't organize, then the ruling class will succeed in reshaping the hegemonic discourse to keep in place their power. Or if we are able to organize, we will change that. And the question is, how do we organize for that? And I offer some ideas onto that, right? Wait for a turn of the tide in terms of judges, right? Change the balance. That might not be happening anytime soon, so that could be problematic. Revert to less expansive interpretations of the constitutional protections that we have, or some scholars have called as Zachary Price symmetric constitutionalism, to try not to favor any group, right? I don't think that's a real solution, and it could also have an impact if we go to like an Origenist theory to talk about these rights. The other, which is important, is to abolish the state action requirement. And the importance of this is when you look at these cases and the formulation that they are doing, you can see that what you have is 2 private individuals actually contending that they have rights. However, for minorities, those rights have to come through the state action to be protected, because the US Constitution, as interpreted by the Supreme Court, does not have horizontal protections as opposed as to what happens in other countries, in which you can exercise certain constitutional rights against others individuals, right? Like a violation on the right of privacy, a violation on the right of dignity, a violation on your right to speak. but that doesn't happen in the United States. So when you have that gate, the power of these claims seems to be diminished as opposed as to what happened in other countries, right? So that's a big issue. And some people have been arguing against the state doctrine, and I'm going to talk about Chemerinsky in a bit, which has also been arguing about that. And the other solution that I prefer is the amplification of constitutional protections. As I already discussed, using the constitutional symmetry will not work, but rethinking state action could actually work in terms of reverting those issues. However, it poses, and Chemerinsky argues that the Constitution actually does not require the state action doctrine, so that it could actually protect individuals against other private citizens. However, when we look at that horizontal direct effect, and it has different names in different countries, this is the one in Colombia, tutela, amparo in Argentina, in Puerto Rico it's called constitutional tort. When you look at those, you will see that there is a strong component in terms of defining dignity. And dignity is a very problematic concept. And we have seen Kennedy trying to implement that into the Supreme Court, and it also has certain problems. Or it could also, you can also think about the unenumerated rights or the penumbra, right, as part of those things that will have to be talking about in that place. So my proposal is that even though abolishing state action could be a good solution, even though the challenges it presents, I would advocate to reappropriate ourselves with one of the tools that conservatives have been using, which is amplifying constitutional protections through legislative action, and do it state by state. So states that actually have open to this type of protections and to protect women and LGBTQ plus people should use those protections, should use the legislature to amplify those protections like RFRA does, right? And then create an issue in terms of those two rights when it goes to court. And that way, possibly we can change the way in terms of these constitutional rights. So that's my idea, and I hope I made it to the 15 or 20 minutes that I had.
Thank you, Anibal. You were great in terms of time. And for those out there who are with us, we may run a little bit over. I have asked the AALS gods if we might have a few extra minutes, since we didn't create the technical problem to start. And so we may run just a bit over, so please be patient. And Kyle, it's up to you now to comment.
Great, thank you. Can everybody hear me okay? Very good. First of all, thank you for having me. I'm really excited to comment on this paper and to see some familiar names in the chat function. I'm sorry we're not together physically, but hopefully next year we'll be able to see each other in person. And so this is a really interesting paper. I saw quite an early version of it, and so my comments will reflect that the early version. There is some more fleshing out today, and I think it's going to end up being a fantastic piece. It really contributes, I think, to this really important conversation that we're having right now over religious exemptions. We have the Fulton case that's currently pending before the court. We saw the Punt and Masterpiece, and there's obviously other religious exemption cases kind of trickling through the system. And so this paper and this project, I think, really creates an important kind of theoretical point of access and entry to kind of consider these claims through a different lens and to argue against them. And in bringing in this political theory, this Gramsci theory, we need all the frames and lenses and points of access that we can get these days in terms of trying to defeat these claims for religious exemption. So I think the contribution here is really significant and important here. Having said that, there's a lot going on, even in the early draft of the paper that I was able to look at here. We have kind of analysis of how we got where we are with essentially what I would characterize as the least marginalized among us, the Christian conservative religious right, claiming victimhood status, and some justices of the court seemingly agreeing with that kind of appropriation of the victimhood status and that shifting narrative that we've seen by the religious right. I think there's also embedded in this paper a critique of the LGBTQIA movement, or LGBT, depending on how you might let Marie-Amelie's paper sit with you. So a critique of the movement itself, right? I mean, I think there is some critique of the hegemonic dynamic that happens within the movement itself in terms of agenda setting and looking, for example, at marriage, which was not inclusive of the needs of the most marginalized within the LGBT community itself. There's a proposal around the doctrinal shift around the state action doctrine. We have the political theory frame or the crisis frame, which, you know, as an aside, as I was reading through this paper yesterday and watching what was happening in the Capitol, I thought, wow, this is very timely to talk about the fall of hegemony and a crisis state, because we were clearly in that yesterday and have been in for quite a while. There's also an overlay in this paper, very interestingly, of the comparative constitutional analysis and this horizontal application of constitutional rights. There's also some robust proscriptive segment of the paper where different proscriptive options are considered here. And so when I say there's a lot going on, that all those things are being addressed here in ways that are really ambitious. But I think there might need to be some sacrifice of fully developing some of them, and perhaps can think about this as a series of 2 or 3 papers, because there's so much important stuff, really meaty stuff going on here. You could look at the crisis lens just vis-a-vis the movement politics itself, or the crisis lens vis-a-vis judicial decisions, or the crisis lens vis-a-vis movement politics or legislative priorities. But lots going on here that was really interesting to engage with. And then the rest of my comments are going to be kind of questions that I had as I walked through and read the paper that perhaps could help you think more fully about where you want to end up with the final draft. So you talk about, you know, the crisis that we're in is the inflection point, right? That we can take advantage of this inflection point and build a revolution from here. And that seems to be what the religious right has been doing kind of at this historical moment for the last decade or so. And as you note, the Alliance Defending Freedom is certainly the supreme leader in how to do this right now. And I think it's an important point that you make about this inflection point as creating opportunity, right? Not necessarily creating change, but creating opportunity for change. It's an opportunity for intervention. It's an opportunity for disruption of current status hierarchies. And so I think that's an important point to make central in what you're talking about here, and then segue that over into the LGBT rights movement and what does that agenda look like. It's a valuable, I think, lens for thinking about intervention here, that it requires action, not just waiting for the breakdown of the old order. I wanted to hear a little bit more in the kind of overview of Gramsci around the morbid symptoms. I think it's a kind of a real central organizing principle to what you're talking and thinking about in the paper. And I wanted to see a little bit more of that up front to kind of lay a stronger foundation for what they are. So maybe some examples from prior crisis situations, even more examples from the current system here. Thinking about, is the morbid symptom kind of a lagging indicator of this crisis in the hegemony, or is it a signal that we have kind of a teachable moment coming forward, or a moment for revolution, for action, or maybe it's a little bit of both. But I wanted to see a little more robust discussion about the morbid symptoms kind of at the front end and the role that they might play in signaling what we're learning about the past and how we can think about the future because of those things. You talk a little bit about the leading class in the paper, and I wanted a little bit more around kind of definitionally how you're defining that for this particular paper here. Do you mean the religious right in particular? Do you mean the Republican Party? Something else? Is it temporally limited? Is it just the Trump era that you're kind of talking about? Because I was thinking back to the 8 years of the Obama administration and the notion of the liberal elite and the progressive movement who to some others in other circles might call that the leading class. And so kind of having a definition around that and then using that throughout the paper as kind of an anchor for the rest of the points in conversation that you want to have here. I like that you brought up the Alliance Defending Freedom. In the draft I read, there was a mention of the FedSoc in terms of the pipeline to the judiciary, but that really concerted campaign by the ADF over decades to really flood the bench has paid off for them over the last 4 years for sure. A couple more thoughts before I close and make sure we have time for some dialogue. Around the weaponization of the First Amendment, I wanted to comment just briefly on your discussion of Bostock in the paper. You mentioned that it was somewhat detrimental to the movement to the extent that it kind of compacted queer identities under just the label of sex and kind of risking the erasure of decades of work of queer activists and scholars to kind of differentiate between those identities and kind of collapsing them. And so I guess I had a question for you in response to that, which is, is it ever okay as a matter of strategy for the movement to go for kind of less than the ideal win? Are incremental steps okay? And if not, why not? And how might that interface with the crisis theory that you're thinking about here? And if it's not okay to kind of go with this kind of expediency, how might we structure litigation agendas to ensure we won't get such kind of compression or erasure in those ways? And I thought a little bit about Ezra Young's article that he recently wrote about how counsel argued that case, the Bostock case, and talked about a trans woman was really just an insufficiently masculine man. And this ties back to Marie Amelie's paper as well. And kind of reimagining what that might have looked like if a trans lawyer had made those arguments in the Bostock case in the court here. And then I think the last, two more points. One would be around the animus doctrine. I think that's a really interesting question these days because, as you point out, the narrative has certainly shifted to the court being concerned about religious people being labeled as bigots. Right. And this is why they really eschew the race analogy in religious exemption cases. Like the people who rely on religion to get exemptions from Title VII public accommodations, they were actually racist. We are just sincerely authentic believers and we're not homophobic, and really drawing that distinction here. So I think the movement has to be very careful in arguing from animus these days. At least in the religious exemption context that we find ourselves in now, given this victimhood argument here, and Roberts and others on the court who seem very, very concerned about branding religious people as bigots. And then a couple of overall themes, and then I promise I'll shut up here. I think one way to strengthen this would be to situate it more clearly within the scholarship that kind of touches on similar themes. I really thought a lot about Reva Siegel and her preservation through transformation framework, and the idea of the crisis as a dynamic process really kind of seems to be adjacent to that and situated within that field of scholarship. I also thought about Nelson Tebe and Doug Nijame and their arguments about third-party harm, the third-party harm doctrine that comes up in these religious exemption cases, and how the harms are not symmetrical, right, between the religious wedding vendor, for example, and the LGBT customer. And so I think you can you could situate it in ways that make it even more compelling than it already is. So I will stop there for now, but and open it up for the rest of the group to weigh in. So thank you for the opportunity. I really enjoyed it.
Thank you, Cal. I've been monitoring the chat. At this point, I don't see any questions, so I'm going to give people a chance to respond on our panel here. So anybody who wants to have sort of a comment at this point about either each other's papers or just thoughts generally. So either anybody, really. Nope. Yeah. Marie Amelie, go ahead.
Okay, thanks. Annabelle, thank you for the really great paper. I think it's fascinating, and I really there's a really interesting shift of a persecuting force becoming a starting to claim that they are a persecuted minority and making those assertions from there. What I wanted to circle back to were David's really helpful comments on my paper. It's always great to have such a thorough read and someone who will just help tweak all these things to make sure it's as good as possible. The point that really struck with me was your question: what are organizations supposed to do? And I do want to clarify that I'm incredibly sympathetic to how hard it is to be in these national organizations, to have limited funds, limited staff, limited time, limited resources, and there's only so much you can do. And so the question is, how do you prioritize what you're going to do? And I think it is very reasonable for organizations to have taken the strategies they have. And so I don't mean to imply that, the fact they haven't taken on sex segregated spaces, I don't want that to be a criticism, but it's a statement of fact. So I will certainly clarify that that in making these things, they're all possibilities, but I really do mean it to be descriptive because it is a very hard situation for all of these attorneys to be in.
We've got just a couple of more minutes. So anyone else? Honorable?
Yeah. Thank you so much for those comments, Emma, and also thank you for your great work. It's always good to read your papers, and I'm looking forward to reading this one as well and using it in my class too. So I just wanted to talk a bit about what Carl mentioned in terms of the animus doctrine and the leading class, and whether the morbid symptoms are a signal or lagging. I think it's both. I think what we see, those changes, right, and that opportunity is telling us something is about to change, right? But sometimes it could be a signal of the chance have already passed, right? So that's why we have to be very careful in terms of taking advantage of the inflection point. And I think that's related to the animus doctrine, right? I think there's a lot of work that has to be done, and I'm having still figure out how to argue against this claims in a way that will be convincing and that will put a stop to it. But if we allow the animus doctrine to become a protection for people claiming religious exemptions, that could be very dangerous in the future, not only for LGBTQ people, but for other type of people that are being discriminated. So I think that's a point. In terms of the leading class, how I define it, and it's very difficult because part of what you were mentioning in terms of the Obama is what Gramsci tells us, right? This is a process, and we see a back and forth, right, in that. So we might, it's very difficult to see it while you're living it, because you think when you're at the top of it that something has changed, but then you see the backlash and you see that hasn't changed yet. So it's easier to go back in history and see when that happened than when you're actually living. So the way that I'm defining the leading class in these cases, it's the people that embrace the still hegemony discourse in terms of patriarchy, heteronormativity. Those are the people who represent that, right? Which in our reality are represented by the Christian right in the United States. So that's what I wanted to say.
Great, thank you. I think we are we're obviously over time, and I know that there are other things coming after us. So I want to thank both Marie-Amélie and Anibal for really great papers. It was a pleasure to read and to hear you both present today, and then also to thank Kyle and David for very, very thorough reading and great commentary on the papers. And I'm sure that there will be a continued discussion offline with each other on these issues. And I also want to thank those of you who I can't see and hope that you're there. And I want to thank you for being here and participating in our panel. The section has a couple of other sessions coming up on Saturday, so please check the schedule and hopefully you can attend those as well. Otherwise, everybody take care, stay safe, and hopefully, a year from now, we will all be sitting in a room together. And I think everyone would certainly like to see that happen. So again, thank you very much, and everybody take care, and hopefully we'll all see each other.